Hi, this is Lori Schonley from correctionalnurse.net, and this is today's quick tip for patient safety in the criminal justice system. Although all healthcare providers should have an understanding of the legal basis of their practice, those of us in correctional settings have an added need to understand constitutional law. When I first entered the specialty, I knew little about the importance to my work of various constitutional amendments and civil rights legislation. I remember clearly the first time I heard the term Section 1983 case used to describe a legal claim. I made a mental note to check out that year and see what happened that was so important. However, in this case, 1983 is not a year, but a section of the U.S. Civil Rights Act of 1871. This act originally was created to protect those who were being harassed by the Ku Klux Klan following the Civil War. Section 1983 of this act is the means through which U.S. citizens can bring forward a civil claim that their constitutionally protected rights have been violated. Section 1983 claims include false arrest, unreasonable searches, equal protection, and excessive force. For correctional healthcare practice, Section 1983 claims involve abridgment of the Eighth Amendment to the Constitution as it relates to healthcare provision. The Supreme Court ruled in the 1976 case of Estelle v. Gamble that denial of adequate medical care to prisoners constituted cruel and unusual punishment, as was protected against by the Eighth Amendment to the Constitution. So, a Section 1983 case is a civil rights case rather than a medical malpractice case. Therefore, instead of looking to determine if the standard for medical care was provided, as would be used in a malpractice claim, a Section 1983 case is looking at the primary determinants of deliberate indifference to a serious medical need. The plaintiff must prove that there was a serious medical need, that medical staff knew about the serious need, that staff intentionally and deliberately failed to provide the required treatment for that need, and the failure to treat caused the inmate unneeded pain or suffering or some similar harm. As healthcare professionals, we're bound by our licensure and our ethical codes to care for injured, ill, and suffering individuals, no matter their position in society. Understanding the peculiar legal landscape of correctional healthcare, however, can help us to appreciate the constitutional importance of our words, actions, and documentation in practice. Until next time, this is Lori Schonley with today's quick tip for correctional healthcare patient safety.